Welcome to Employment Law This Week. I'm George Whipple. Is the end coming for disparate impact liability? On April 23, 2025, President Trump signed Executive Order 14281, restoring equality of opportunity and meritocracy. The EO seeks to eliminate the use of disparate impact liability in all contexts to the maximum degree possible. Epstein, Becker, Green's Mark Mandelman tells us what this means for employers.
Broadly, the executive order states that the federal government will no longer rely on disparate impact theory to pursue enforcement of the anti-discrimination laws through either regulation, litigation, or agency enforcement actions. However, the executive order does not and cannot overturn existing Supreme Court and other judicial precedents, including the seminal Griggs versus Duke Power Supreme Court decision from 1971, nor does the executive order change the fact that disparate impact liability was adopted into an amendment to Title VII of the Civil Rights Act of 1991, or in the many state and local anti-discrimination laws that explicitly recognize disparate impact liability.
Epstein, Becker, Green's Nathaniel Glasser points to New York City as one of those local jurisdictions. The city has one of the country's strictest laws requiring disparate impact audits.
New York City Local Law 144 went into effect in July 2023. That law requires any employer within New York City that's using an automated employment decision tool, including an AI system, to make or assist in making hiring or promotional decisions, to conduct an adverse impact analysis of the use of that tool in the process, to publish a summary of that adverse impact analysis on their website, and to provide notice to candidates that AI is being used in the hiring or promotional process.
Nathaniel and Mark tell us how employers maintain compliance in situations like this, where federal guidance is at odds with state and local regulations.
There is an inherent tension between the federal government's decision to potentially step back from the disparate impact theory and state and local laws, such as New York City Local Law 144, that would require employers to conduct an adverse impact analysis to be compliant. We're also watching a congressional spending bill that includes a provision that would preempt any state or local effort to regulate AI. So employers must be cognizant of the fact that the federal government is attempting to preempt state and local level regulation of AI, but for the time being, they should continue to follow these laws as they evaluate their use of AI in employment.
The executive order does not prevent a plaintiff as an individual or as a class from asserting a disparate impact theory claim in a private lawsuit that could be recognized by a court or a jury, even if the EEOC or DOJ will not pursue such a case under this administration. Therefore, notwithstanding the executive order, it is still very important for employers to continue to ensure that their decision-making is not having an adverse impact on individuals in protected categories.
Thanks, Mark and Nathaniel, and thank you very much for watching. We'll see you next time.